Title 17 is the final chapter of the revised Corporation Code. Because these are labeled miscellaneous provisions, they are frequently overlooked in study. This oversight creates a specific opportunity for bar examiners to test the precise boundaries of jurisdiction and compliance. We are conducting a forensic, sequential breakdown of sections 173 through 188, focusing on the specific mechanics where practitioners often stumble. This title serves as the code's regulatory engine, shifting the SEC from a registry of records to an agency of active enforcement. Section 173 defines outstanding capital stock as shares issued under binding contracts, explicitly excluding treasury shares. When computing quorums, deduct treasury shares. Remember TIE, total issued except treasury. As long as a binding contract exists, shares count regardless of payment status. Section 174 moves from math to structure, granting non-stock and special corporations flexibility in how they name their governing bodies. Under the name rule, non-stock, any moniker except trustee, entities like universities or religious groups can use titles like Board of Regents or Council of Elders. This flexibility does not extend to regular stock corporations. They are statutorily required to use the term Board of Directors. Section 175 establishes the SEC's financial framework through the fees rule, authorizing the retention of corporate charges. While most government fees are surrendered to the National Treasury, the SEC can deposit these fines into a separate account for its modernization and operational expenses. Together, these sections define the arithmetic and financial autonomy of the modern corporate entity. Section 176 addresses the prevention of anti-competitive practices in corporations vested with public interest. It is a mistake to assume the SEC sets ownership caps. That authority remains with Congress, acting upon the recommendation of the National Economic and Development Authority. Section 177 mandates submitting the General Information Sheet and audited financial statement. Failing to file these 3 times within a 5-year window triggers delinquency status. This 3-5D rule applies whether failures happen consecutively or intermittently. Delinquency is not immediate dissolution. The corporation is granted a 2-year period to cure the defect before the SEC moves for revocation. Section 178 grants the Commission visitorial power to examine corporate records and supervise activities for compliance. Because this power is so broad, the results of these examinations are kept strictly confidential by law. There are 3 exceptions under the VCE rule: when the law requires disclosure, when it is necessary to protect the public, or when the results are required as evidence before a court. The SEC functions as an investigative authority, probing corporate internals while maintaining a statutory wall against the curiosity of competitors. Under Section 179, the Commission can issue ex parte cease and desist orders to stop imminent fraud. Lower courts cannot interfere. No court below the Court of Appeals has jurisdiction to issue an injunction against the SEC's powers. Section 180 institutionalizes the digital transition through the e-file mandate, requiring an electronic system for all registrations and report submissions. This makes physical paper filing a secondary option rather than a legal right. The goal is a permanent shift toward electronic monitoring. Section 181 allows unlisted corporations to include arbitration agreements in their bylaws to resolve intra-corporate disputes. This does not apply to everything. Disputes involving criminal offenses or the interests of third parties remain non-arbitrable and must be handled by the courts. Section 182 clarifies the regulatory boundaries regarding the political sphere. All jurisdiction over party list organizations has been transferred from the SEC to the COMELEC. The SEC no longer has the power to revoke their registration. These provisions protect the Commission from lower court interference, while defining the areas where its authority must yield to other constitutional bodies. Section 183 establishes the Corporation Code as a general law that does not repeal special laws. For highly regulated entities, follow the SCSL rule. Special corporations equal special laws. The RCC applies to banks and insurance companies in a supplementary manner. This means the SEC cannot unilaterally dissolve a bank without complying with the specific regulations of the Banco Central ng Pilipinas. Section 184 reflects the constitutional protection of vested rights. No right, remedy, or liability is removed by the dissolution of a corporation. Dissolving the entity does not erase its debts. Any liabilities incurred before the corporation ceased to exist remain attached to the corporate assets during liquidation. A corporation is a legal fiction with specific limits. It cannot override specialized regulators, and it cannot be used to extinguish existing legal obligations. Section 185 provided a transition period of up to 2 years for existing corporations to align with the new requirements of the revised code. This ensured the SEC could not arbitrarily suspend an existing corporation's license immediately upon effectivity for failing to meet new criteria, such as the appointment of an independent director. Section 186 contains the separability clause, ensuring that if one provision is found unconstitutional, the rest of the code remains in effect. Section 187 is the repealing clause. It expressly and completely replaces Batas Pambaza Bilga 68. For any corporate action occurring after 2019, citing the old thresholds or rules from the previous code is a fundamental error. Section 188 defines the exact moment this transition occurred. While most laws take effect 15 days after publication, the RCC took effect immediately upon the completion of its publication on February 23, 2019. The transition is complete. Corporate governance in the Philippines is defined exclusively by this revised code. These miscellaneous provisions provide the structural integrity for the entire revised corporation code. We detailed quorum calculation mechanics, the limits of judicial interference, and the non-consecutive triggers for delinquency. True success in navigating the code requires looking past the general principles and mastering these final forensic details. You now have the blueprint for Title 17. Use it.